Thank you, everyone, and welcome to a Tuesday edition of the Employer Handbook Happy Hour. I am Eric Meyer. I am the publisher of the Employer Handbook blog. I'm also a partner in the Labor and Employment Practice Group at Pearson Ferdinand. And let's do these introductions quickly. I'm going to go around the wheel and let everyone introduce themselves. To my right on my screen is Dan Schwartz. Dan, how you doing?
Eric, good to be with you. I'm Dan Schwartz. I am a labor and employment attorney at Shipman and Goodwin, based in Connecticut and New York and all around. And I'm also the publisher of the Connecticut Employment Law Blog. Good to be with you.
Thanks for being here. And going clockwise, Amy Epstein Glock. How you doing, Amy?
Hey,
Good to
how are
see
you?
you.
Good to see you. I am Amy Epstein Gluck. I am the chair of the Employment, Labor, and Benefits Department at Pearson Ferdinand and a longtime partner of Eric and Desi's now. I'm also employment counsel to the firm, and I work all around the country, especially in New York and the DC area.
Thanks for being here.
Thank
And at about 7 or 8 o'clock on my screen, although it's 9 o'clock where she is right now in California, it's Desi Day. Desi, how are you?
Good morning, everyone. I am Desi Day, and I am a partner in California practicing all areas of employment law, class action work, advice and counseling, anything that you need in the wonderful state of California.
Awesome. Thanks for being here. And last but certainly not least, John Hyman. Hey, John.
Hey Eric, thanks for doing this. Good morning or afternoon, everybody. I'm John Hyman. I chair the Labor and Employment Group at Wickens Herzer Panza in Avon, Ohio, which is a suburb of Cleveland. I also chair our craft beer practice. So if there's any craft breweries on the call, hit me up afterwards. And we were talking before we started. I think we're going on 16 years now that at least I think you, me, and Dan, Eric have been doing the blogging thing, but 16 years now writing the Ohio Employers Law blog. So good to be here. Good to see everybody.
Congratulations. We'll have a sweet 16 for you when it's
There you go.
all over.
I think yours is almost as old. So
I'm getting there. I'm getting there, but I still can't drive yet. Anyway, let's go through a couple of the other housekeeping measures. Yes, folks, we are recording this. I did remember to hit record. This will be posted on the YouTube channel hopefully later today. I have other work to do, but hopefully we'll get it up later today. Link will go out hopefully tomorrow. So if you want to share it that way, and if you're watching the video on YouTube, like give us a like, subscribe, comment, all that good stuff. Disclaimer, we're all lawyers. Some people on the Zoom right now may be actual clients of one or more of ours, but for the next hour, you're not. Doesn't count, right? We're not giving out any sort of legal advice. We're not creating any sort of attorney-client relationship. If you don't take advice from five attorneys on a free Zoom, right? Like if you need real tailored advice, and don't post it in the chat either. Like we usually skip those questions. But if you need real advice, just call your lawyer and pay for it. And if anyone needs closed captioning, it is turned on. Just use the CC button down at the bottom towards the right, and you can get some captions. All right, we've got the introduction out of the way. We have a full agenda here. Lots of changes, or maybe not so many changes that we're talking about going forward. And Amy, I want to start with you. Tell us what's in store at the EEOC for 2025. Look in your crystal ball. Tell us what's going on.
Okay, look in my crystal ball. And you know I have one too. So, usually with the EEOC, you don't see a lot of specific changes, but I think we're going to see changes over the next 4 years, more than over 2025. The Democratic commissioners hold the majority until 2026. But Andrea Lucas, Commissioner Lucas, who was appointed by President Trump in his first term, is the only Republican commissioner. So he will likely appoint her as chair and then another Republican to fill the vacancy and then name that person probably as vice chair. That's what my crystal ball says today. the current chair is Charlotte Burrows, and the vice chair is Jocelyn Samuels, and all the Democratic commissioners, we assume that they would stay on until their terms expire, which vary from 2026 to 27 to 28. Andrea Lucas's term expires in July of next year, but I would expect President Trump to nominate her for another term. So it should be busy over the next several years. And as Commissioner Lucas as chair, the chair is responsible for the administration and implementation of policy and the financial management and development of the commission. So I would expect to see some shifts in focus. But before I talk about that, we can't leave out the general counsel of the EEOC. So Carla Gilbride was confirmed last year to a 4-year term, but she will likely be replaced. I would expect President Trump to replace her as soon as he is in office. And a new GC will likely focus less on litigation against employers, just like the EEOC did in the first administration, the first Trump administration. I would expect this commission to be less litigious. The current EEOC really has been going after employers hard in the courts and otherwise, and much more focused on enforcement and education and trying to, teach employers more trainings, more programs, rather than what some might view as attempted expansion of legislation through rulemaking or guidance. Commissioner Lucas has been very vocal about EEOC guidance this year in her opposition to EEOC guidance, and I would expect to see more of that. I'd expect to see changes in position, especially when it comes to religion and transgender issues. In April of this year, the EEOC harassment guidance came out, and Commissioner Lucas drafted a very adamant opposition, calling the guidance an assault on women's sex-based privacy and safety rights at work, as well as on speech and belief rights, claiming the EEOC ignores biological reality and disregards decades of safeguarding principles for women and girls. So she considers sex to be binary and immutable, and I would expect to see a walk back on transgender issues over time with the guidance. Once the Republicans have a majority again. I would also expect to see some walk back there, and with the Pregnant Worker Fairness Act on abortion and menstruation. I would expect to see that the EEOC either rescinds or revises its recent enforcement guidance on these topics, toning down, if not removing provisions relating to the use of pronouns and dead names and preferred names and restroom rules, as well as unlawful gender identity harassment. Commissioner Lucas has been really, really critical of these provisions, and I would expect to see some of that walk back, if not fully revised. We might also see explicit provisions relating to reasonable accommodation of employees' religious beliefs in this regard. So I think the changes are not going to occur right away. I think they're going to happen over time. But to be sure, as to the guidance, as to the Pregnant Worker Fairness Act, I think we'll see some walk back here. They'll likely remove, I would expect to see the EEOC remove the requirement that employers make reasonable accommodations for employees having elective abortions and go from there. I would think that DEI, the EEOC will likely take a narrower view of what is and what is not going to be permissible under DEI initiatives. It is no secret that since Students for Fair Admissions, DEI programs and policies have been under attack. During the first Trump administration, there was an executive order restricting the federal government and those contractors from offering certain types of diversity training on perceived controversial topics like race or sex stereotyping or scapegoating. And I would expect to see similar ones coming up with this shift. It's unclear right now if the Department of Justice will also challenge the DEI policies and procedures at companies. But I would expect to see this most likely from the EEOC over the next few years. And I'll take a breath there.
All right. Well, thank you. You covered a lot.
Covered a lot.
John, there's a four-letter word. No, I was going to say a four-letter agency that employers have had a tough time with over the past 4 years. Emblematic of President Biden saying that this would be the most labor-friendly administration that we've ever seen. The National Labor Relations Board has not let the president down, but I expect things are going to be changing over the next 4 years. Would you agree?
I would definitely agree. Jenna Bruzzo, the NLRB's general counsel, is, the most stridently pro-union NLRB general counsel the board has ever seen. She has put in place really significant and sweeping changes in the last 4 years to board policy, a lot of which has made its way from her advice memos down to board decisions. And, I would expect a lot of that to change at some point in the next 4 years. Starting with the appointment of a new general counsel. If you remember when Joe Biden came in, one of his first actions as president was to fire the NLRB's prior general counsel, Peter Robb. I would expect we will see Jenna Bruzzo fired, if not on day one of the Trump presidency, very, very shortly thereafter. We don't know who the new general counsel of the NLRB will be. We assume it will be someone significantly less friendly to labor unions than Jenna Bruzzo is. Given the appointments that we've seen President Trump announce so far, like Howard Schultz, the former CEO of Starbucks, wouldn't surprise me as NLRB general counsel, although I don't think he's a lawyer. But we will see someone very anti-union come into that role that is going to implement significant changes. Now, the trick here, or the problem that the that new general counsel is going to face, is that right now there is a 2-to-1 Democratic majority on the board. And there are 2 open seats that are currently sitting with the Senate to be filled, one Democrat and one Republican. If they fill those seats, prior to the end of this current Senate term, there will be a 3-2 pro-union Democratic majority sitting on the NLRB until 2026. I think you will see those seats not be filled, and what you will see is President Trump come in and fill those seats early in his administration, giving him a Republican majority, a pro-employer, anti-union majority on the board. That will then allow the NLRB to ratchet back a lot of the changes, the pro-union changes we've seen over the last 4 years. So when you think of some of the more like jaw-dropping decisions we saw come out of the NLRB, things like severance agreements violating employees' rights to engage or protect a concerted activity, non-disclosure and confidentiality clauses in agreements violating employees' rights to engage or protect a concerted activity. I would think those decisions would be reversed. The CEMEX decision, which essentially wrote card check recognition into the National Labor Relations Act, or by requiring an employer to recognize a union upon a majority presentation of cards unless the employer asks for an election within 14 days. So it flipped the burden of who has to ask for an election. I think we'll see that decision go by the wayside. We will see a return to more employer-friendly rules on workplace rules and protect a concerted activity. So the employer handbook that you used from 2016 to 2020, you might want to dust that off and put that back into circulation, because a lot of the rules in terms of policies that do or don't violate employees' Section 7 rights, I think we'll see a return to the more employer-friendly rules in that regard in the next Trump administration. And then just last week, the NLRB enacted a ban on captive audience speeches, um, and um, and I think we'll see that decision probably get overturned at some point in the next administration as well. These things don't happen overnight. You require cases to be filed and be litigated before they get to the board, and so these will be. These won't happen on day one, but they will happen, I think, at some point in the next administration. I think where you will see the more quick changes will be things like less reliance on 10J injunctions in board proceedings. Um, you will see more narrow remedies sought in NLRB cases. Jenna Brutzer took a very wide um, liberal view of remedies that are available to employees. And I think we'll see a much narrower set of remedies sought in board cases. So, the NLRB is a political body, as the EEOC is, and we do see flip-flops of policies as administrations come and go. And I think that the general theme here, or the general takeaway here, is we will see a flip back to the more employer-friendly, union unfriendly rules that predated the Biden administration, more akin to what we saw during Trump 1.0 when we get when we get Trump 2.0.
Thank you. And folks, that's not unique to Trump versus Biden. That's typically what happens when you go from a Democrat in the Oval Office to a Republican, and then when it goes back to a Democrat at some point, whoever that may be, it becomes more union friendly. I mean, that's just generally the way it works.
Yeah, not unusual. I just think that a lot of the changes we saw in the last 4 years were so out of the ordinary from what we're used to seeing from the board that the switch back might seem a little more jarring, because the last 4 years at the board for employers, at least to me, felt jarring. So.
That's fair. So I am tasked with talking about the FTC's non-compete rule and then the Department of Labor and changes I would expect to see there. I'm going to yield my time on the FTC's non-compete rule to Desi and Dan. Dan's going to be talking about the Loper Bright decision and how that may impact judicial determinations of federal agency interpretations of the law. And Desi is going to be talking about some state law issues. So I'm going to yield FTC to them. All I'll say about that is Lena Khan, who sits as the chair of the FTC. And really, for most employers, like the FTC isn't a federal agency that we talk about that much, but just because of the non-compete rule, it's gotten our attention. And Lena Khan is the chair, and she is very much in favor of the non-compete ban proposal. Will she survive in a Trump administration? Look, I don't want to see anyone get fired, but I think, just thinking about it rationally, probably not. Although I don't think anyone has come out yet and said that she would be removed or not renewed as chair, but I wouldn't expect her to be there. Let's talk a little bit now about Department of Labor. So I was going to talk about the FLSA salary level test and how that went into effect. We saw a little bump in July. We're going to see another bump in January, but a federal judge in Texas had different things to say about that. So, and that judge relied upon Loper Bright. So I'm going to yield the discussion on FLSA salary level to Dan. What I'm going to do is I'm going to talk about four other things. I'm going to talk about minimum wage. I'm going to talk about opinion letters. I'm going to talk about paid leave. I'm going to talk about employee misclassification, specifically independent contractor versus employee. And then maybe if I have time, I'll talk about joint employer tests. Okay. So minimum wage, still $7.25 at the federal level. You know the last time it was raised, folks? July 24, 2009. I read an article somewhere like the Black Eyed Peas were at the top of the charts. I mean, it's been a while. President Trump, as far as I know, has not taken a firm position on minimum wage. I know I read on NPR that during a presidential debate 4 years ago, he said he would consider a $15 an hour federal minimum wage hike as long as it doesn't hurt small businesses. But during his campaign this time, he was asked about it when he was doing his photo op at McDonald's, and he didn't really directly answer the question. This is just me talking in light of this administration's focus on limiting government's role. We have the Department of Government Efficiency that's going to be run by Elon Musk. Uh, I don't see the federal government stepping in to raise minimum wage. I think that could be something that is easily done at the state level, or more easily done at the state level, or politically, that could be the message that it can be done at the state level. So I wouldn't expect to see an increase, at least not in 2025. What I would expect to see, however, are the return of opinion letters. So what we used to have back in the day is employers, and not just employers, but usually employers, asking the Wage and Hour Division of the Department of Labor. So this is the section of the Department of Labor that administers the Fair Labor Standards Act and the Family Medical Leave Act. They would send in these not so hypothetical situations, kind of like you folks do in the chat, and they'd ask for an opinion, right? Like, does this comply with the FLSA? Are we violating the Family Medical Leave Act? And if your letter happened to be selected, the Wage and Hour Division would write eponymously an opinion letter. And the opinion letters are not law, but they do, and maybe in light of Loper Bright, they might not be worth the paper they're printed on. I don't know. But they at least do reflect the Wage and Hour Division's position on certain FLSA and FMLA issues, and employers and employees generally rely upon them. So during the Obama administration, we didn't see much in the way of opinion letters. There was more generally applicable administrator interpretations. During the first Trump administration, boom, opinion letters came back. Lots of them. Then during the Biden administration, not so much. Really, I don't think there was any until within the last 2 years. I think we've gotten 4 of them. So I would expect to see in the Trump administration, with a Trump appointed solicitor, a ramping up of opinion letters. Okay. Paid leave. Well, we still don't have it on a national level, right? We are one of 6 countries in the world with no national paid leave program. We've seen many proposals over time, but the devil's really in the details. Like, who's going to pay for it? Are employees going to pay for it? Are employers going to pay for it? Is the government or some like insurance company going to pay for it? What size businesses are going to be covered? Is it just large businesses are going to have to provide paid leave because it would be too much of a burden on your small businesses, or will every business be covered? What types of leave would be covered? Is it going to be your typical like serious health condition for yourself, or would it be anything that's covered under FMLA, or would it also include domestic violence and for victims of domestic violence, stalking and the like? There have been many different proposals. President-elect Trump has not announced his position on paid leave. During the first administration, there were tax credits for childcare, and that seems to be more of the emphasis now, or at least in the talk leading up to the election, like childcare, rather than taking paid leave for yourself as an employee. So do I expect a change in 2025 on this? No, I don't expect paid leave to come in 2025. Again, something more that will be focused upon at the state level, and Desi may be able to touch upon that then. Employee misclassification, independent contractor versus employee. So let's take you back to the first Trump administration. So the Department of Labor creates a 5-factor test where there are 2 core factors to distinguish between who is an employee and who is an independent contractor. Let me pause there for a second. Why is this important? Employees, the non-exempt ones, they're overtime eligible, and you have to pay the minimum wage. Independent contractors, nope, no minimum wage, no overtime. So the test that was developed in the Trump administration was these two core factors were the nature and degree of control over the work. So the more control that a company asserts, the more likely it is that the person's an employee, and the worker's opportunity for profit or loss based on initiative and or investment. Okay. The more opportunity for profit or loss, the more likely it is that they're an independent contractor. There were some other factors too, like the amount of skill required for the work and the degree of permanence in the relationship, and whether the work is part of an integrated unit of production. But those first two factors I talked about really steered the ship. Under the Biden administration, that was scrapped. And basically, the Department of Labor took the position that all the factors, you just throw them in a pot together, you stir it around, you taste it, and no one factor dominates. And you see what it tastes like. If it tastes like, well, this is getting weird. If it's independent, if it maybe smell. If it smells more independent contractor, then it's independent contractor. If it smells more employee, then it's employee. So that's the current state of play right now. I would expect at some point, whether it's 2025 or beyond, a return to the old test where the two factors of control and profit or loss predominate. And finally, joint employer test. So during the Trump administration, there was a 4-factor test that the Department of Labor established. And by the way, there's a National Labor Relations Board joint employer test, there's a Department of Labor joint employer test. I know this can get very confusing. I'm just focusing on the Department of Labor. The test was effectively designed to make it harder for two companies to be joint employers, okay? And there were 4 factors. Whether a potential joint employer hires or fires the employee, supervises and controls the employee's work schedule or conditions of employment to a substantial degree, determines the employee's rate and method of payment, and maintains the employee's employment records, right? Those were the 4 factors. And again, mostly designed to try and keep two businesses separate and not in joint employer status. During the Biden administration, the Second Circuit, where Dan practices, blew up a bunch of that joint employer test. And then the Department of Labor just came in and said, we're going to scrap that thing altogether. There was no replacement. So it's, and frankly, does it really matter? Maybe not in light of Loper Bright. And this is a pretty nice transition for Dan. So I keep using these terms, Loper Bright, Loper Bright. What the heck does that mean? Dan, please decode this for the audience and tell them how it's going to impact the state of play in 2025.
Yeah, absolutely, Eric. And, it would be nice if case names had better names, but we're stuck with Loper Bright, I feel like, for the next 30 or 40 years, much like we were stuck with Chevron, which was the case that overturned as well. So, all right. So here's your 1 minute. I'm going to put on my law professor hat and walk through the Loper Bright decision. So if you missed it, back in June, the U.S. Supreme Court issued a very, some might say, controversial decision in Loper Bright Enterprises versus Raimondo, which overturned a 40-year-old Chevron doctrine. That doctrine, which had been developed by the Supreme Court before, required courts to defer to federal agencies that had a reasonable interpretation of ambiguous statutes. That rule was thrown out. And what Loper Bright says is we're going to revert to the understanding that allegedly dates back to the Constitution framers and reflects a 1946 Administrative Procedure Act requirement. And that is that questions of statutory interpretation, in other words, how we should be looking at the statute, are issues of law that are properly decided by the courts using their traditional tools with no essentially either thumb on the scale or preference to the interpretive preferences of the executive agencies. And really, when you think about it, what was happening over the last 20 years in particular is Congress would pass laws, many of which were ambiguous, and say, hey, administrative agencies, you figure it out. And so the agencies came out with guidance. Now, in some cases, arguably, they went far beyond what statutory text has said, and we've recently seen court cases striking down these types of regulations. But the Supreme Court goes one step further and says it's up to courts to exercise independent judgment when interpreting the statute. Now, that doesn't mean that the agency's views are irrelevant, and courts can still seek aid from those interpretations. You could really see this on complex scientific questions where the courts may not have the area of expertise. But the majority in Loper Bright emphasizes that more weight should be given to agency interpretations that are issued contemporaneously with the statute and have remained consistent over time. So, given this sort of background here, I think everyone in the short term said there's going to be continued uncertainty because the federal courts are going to take a more active role in scrutinizing agency rulemaking. And we've seen that over the Fifth Circuit, everyone's favorite circuit to either love or hate, came out with a decision in August that overturned the Department of Labor's so-called 80-20 tip credit rule, which basically was saying that if certain amount of time is spent doing work, that the tip credit could or could not be applied. But the reason and why we're having the discussion here today is because I think the Loper Bright decision also means that it's less likely that we're going to have this sort of back and forth when a new administration comes in and changes political parties, because conceptually the underlying law really shouldn't be subject to reversal. As the Supreme Court said back in June, the law is the law, and the regulations that have been subject to interpretation for years really shouldn't be changed just because of a change of administration. So I think those who are predicting that the regulatory state is really going to shift dramatically under the Trump administration, I think that has to be tempered by the Supreme Court's decision in Loper Bright. And so as much as the Fifth Circuit, for example, over the Biden administration has overturned some of the Biden administration rules, you can certainly see now other circuits, maybe the Second Circuit, which Eric highlighted, maybe the 11th Circuit, Ninth Circuit, tough to tell whether those circuits, and then maybe the DC Circuit as well, will come in and say, hey, Loper Bright says we can't really be deferring to agencies anymore, and strike down any attempts to flip the script on the regulations. So when John was talking about the NLRB shifting from by the political party and shifting their views, I do think in the long run, Loper Bright will have an impact on it. Now, it may be that the rules get flipped back to the way they were, and that'll be viewed more as the status quo. But I think those who are predicting a administrative state run rampant are likely to be surprised when Loper Bright gets thrown back in their face as well. I'd say the one other point that I wanted to raise here is there are certain things that Trump administration could still do with executive orders, and it's not yet clear whether those executive orders are going to be challenged in the same way. So just throw out an example. Executive Order 11246 requires federal contractors to recruit women and minorities and develop affirmative action plans analyzing racial and gender demographics of employees. Would the Trump administration, and this executive order dates back to the Johnson administration, will the Trump administration just overturn that? And what does that mean in terms of the domino effect on it, particularly where this executive order has been in place for close to 60 years? So I think Loper Bright will have an impact on what some of the agencies do. I think its impact will be far more muted when it comes to executive orders, of which the executive branch has a good deal of deference here. So we could talk more, but I think that's what I wanted to cover on Loper Bright. I think it's a fascinating time because everyone who was bemoaning Loper Bright being the downfall of regulations that the Biden administration was proposing may start to like the Loper Bright rule when it comes to the Trump administration regulations.
Another change that could be coming early, maybe 2025, is in artificial intelligence. I know there was a Biden administration executive order on the safe, secure, and trustworthy development and use of artificial intelligence, but we've got some pretty technologically savvy people, or people who are advertised as technologically savvy, who are part of the Trump administration. One of them happens to own X. So I wonder how this new administration, John, you're smiling, might approach artificial intelligence.
Well, I think the Biden administration's executive order is going to be out the window. I mean, Trump is going to rescind that, I think, very early on in his administration. I think we're going to see a much more hands-off approach to AI policy, for better or for worse, depending on how you look at it. I think a lot of what the Biden executive order focused on were things like algorithmic discrimination. I think we're going to see no focus whatsoever on trying to inhibit AI algorithms from discriminating. So if you take it like to the HR context, where um, does a bot's algorithm um, have a disparate impact by screening out minority candidates or female candidates or older candidates or whatever. We were poised to see some efforts to, require the AI to not discriminate in how its algorithm impacted job applicants, for example. I think that's going to I think that focus is going to disappear in the upcoming administration. Um, I think um, I, I think we're going to see an effort to allow the tech companies to develop AI how they want to develop it. I think without a whole lot of regulatory guardrails from the upcoming administration, which, I was an early critic of AI just because before I really understood it, because it scared the hell out of me. Because I've seen Terminator and I've seen how it ended, and it's not a happy ending for humanity, and so it scared me. As I've delved into AI and I've got more comfortable with that concerns me less. But when you have an administration that will allow these tech companies to develop the technology without a lot of government oversight or guardrails, those concerns start to creep back in. So it gives me pause as we move forward over the next 4 years. And this stuff moves fast. There's if you look at where AI was barely on the radar 4 years ago, if it was on the radar at all, look at where like ChatGPT is today versus where it was 12 months ago. 4 years from now, I mean, who knows where it's going to be? My brain can't wrap around what the AI algorithms are going to be able to do 4 years from now. And without government oversight or sufficient government oversight, it doesn't give me a real warm feeling with the development of this technology.
Yeah, and if I could just add to that, I think in the absence of federal regulation, I do think we're going to see independent parties try to move this at the courts to try to impose liability on employers and businesses for maybe unintentional discrimination, as you were mentioning, John. And so while we may not see it at the regulatory scheme. I wouldn't count the courts out on this either. And I think that's probably also a good segue to Desi, because while we may not see it at a federal level, what we certainly saw during the first Trump administration is developments at the state level. And that's we've seen that in New York City, certainly Illinois, and California. Some of these big states starting to regulate AI, and that's probably as much as I would like a federal one size fits all system, we're probably going to get this hodgepodge at a state level.
All right, Desi. We've been waiting.
Okay,
Yeah,
let's
you're
bring it,
up.
right. Let's bring it down to the state. So we talked about John and Dan and Amy and Eric spoke about the shifts that we are likely to see at the federal level as the new administration steps in. And I just kind of want to bring it back to the basics. So under our general framework, states have quite a bit of autonomy in terms of making their own employment laws, right? They're limited by federal preemption rules, but generally retain, especially in the employment law arena, considerable amount of authority to make their own laws. So the federal law generally sets the minimum, and the states step in and impose stricter rules. For some states, like my home state of California, a very robust employment protection. But generally speaking, when we're thinking about the federal government, let's say, relaxing the rules or stepping back on enforcement, the likely outcome on the state level is going to be one of two ways. They're either going to align with the federal government, or they're going to diverge from the federal government. So with the focus on deregulation, let's say, the trickle-down impact for some states is to shore up the state regulatory efforts. For instance, when the Trump administration 1.0 kind of, held back on the minimum wage increase, what happened at the state level in California, my home state, and New York and Massachusetts and other states, they ramped up the regulation of minimum wage and increased, significantly the minimum wage. So you were going to see in other areas, for instance, revised joint employer standard that some of our speakers spoke about at the federal level back in the day when we had the first Trump administration, made it harder at the federal level to hold the parent companies liable for labor violations of subsidiaries or franchisees. Well, what happened is California counteracted with protection of workers in the franchise system and enacted a couple of, important legislation, one of them being the ABC test of classification for independent contractors, which in addition to impacting the gig industry had impact on the franchisors' liability and classification of employees as independent contractors, and the other legislation being the Fast Food Accountability Act, another counteract to what happened at the federal level, right? So another example is when the federal government took a stance on the union protection for employers, and sort of back in the day again, Trump administration 1.0, protecting employers. Some states actually aligned with the federal government and passed right to work laws. And, what these states are: Kentucky and, Mississippi and Wisconsin and West Virginia and other states, right? So in similar ways, when we talk about alignment, as the federal government has made a priority, or at least the incoming administration speaks a lot about immigration, right? One of the priorities of the incoming administration. What we saw back in 2017, when the first Trump administration came in the office, the E-Verify mandates that were picked up after the federal government impose stricter immigration policies, you saw some of the states aligning with that policy and, enacting essentially a similar sort of mandate at the state level. Other states counteracted with the sanctuary laws, right? So California being one of them. One of the, federal, agency, OSHA, is likely to be impacted by the new administration. Back, when Trump took office in 2017, we saw a pullback from enforcement in terms of the overall violation rate. That is likely to happen again, which back then resulted in California and Washington, for instance, stepping up and strengthening their workplace, safety rules. So we're likely to see a similar shift with the new administration coming in. So states taking initiatives on the paid sick leave and the minimum wage are sort of another counteract point to the federal government stepping back and not doing much about it. New York, Massachusetts, California, again, gradually increasing the minimum wage and enacting laws that provide for paid sick leave. And another interesting point I think Amy touched on is in the discrimination arena. We're having now states stepping up and impact and expanding the protected classifications, right? So gender identity, reproductive rights, and all of those extra protections that state laws can put in on top of the minimum standard provided by federal law is another term. So the way I think of it is align or counteract. And so that's what is expected on the state level.
Great way to put it, Desi. They're either going to align with the federal government's position or take a counter position to get the benefits for their constituents that they want to see. We saw that with paid sick leave, and paid parental leave. There's no national paid parental or sick leave. So one by one, states have been falling in line with different types of paid sick and safe time leave, as Eric mentioned, with the safe time, as well as paid parental leave.
And let me not forget the non-competes, right? California is staying the same. Even if it relaxes on federal level, which way we go, California tends to lead the way. And I think we're headed in that direction, nationally. But nothing is going to change. But, non-solicitation agreements and non-competes have been for decades outlawed in California and invalid. So that is not going to change whichever way the federal government shifts. And that is going to likely be, an initiative that other states, and we have seen it happen, be picked up. And so, keep an eye on your state laws because they are driven by the climate and the priorities of each state. And those usually don't shift that much considering the federal level.
Yeah, these are all great points. I mean, things that employers are usually preparing for at this point, maybe it's even a little bit late, but you still do it. Like if you're going to update your handbook, like don't put that off, right? Like handbooks are generally state law driven. So if there are changes at the state law level that you want to incorporate into your handbook or just make sure it's up to date, now's the time if you haven't done it already to do that. I mean, if you're putting together your training sessions for 2025, whether it's anti-harassment or you're training your managers on FMLA or Pregnant Workers Fairness Act or anything like that, like don't put those trainings off because we have a change in an election that has resulted in some changes. Like those are still going to have a lot of value.
Hey, Eric.
Yes.
I saw one of the questions and I didn't have time to touch on it before, but I just want to mention and you had touched on it before, this Texas case that overturned the FLSA salary level. So we were going to talk about in the Loper Bright analysis, which is this the type of regulation that is going to be overturned as sort of a broader attack on the regulatory scheme. And the Texas judge took the bait and said yes. Now, whether that'll be upheld at the Fifth Circuit and above remains to be seen, but the court's decision last Friday struck down the Biden administration white-collar exemption rule, which increases the salary threshold a few months ago and was poised to do so in January. And what that means is we are now reverting back to the existing salary threshold, which for most people is fairly easily met. And so you could still have people that are, again, now exempt from being paid overtime under the old rule, where they were going to have to be paid overtime if their salary didn't change. So it's causing a bit of a mess because there are some employers that either raised their salaries to meet this new threshold or had reorganized things to make them non-exempt. And how much employers are going to be willing to roll that back is a big question. But at least for those that were considering it in January, that's off the table as of right now.
Yeah, I don't know. I don't know that I would roll back a salary increase. I mean, you
Right.
certainly can, but I would think you'd have some resignations if you said, oh, you know what, just kidding. Let me pay you $20,000 less,
Yeah.
especially with the highly compensated employee exemption.
I also think it's a practical matter, since someone pointed out in the comments the duties test is alive and well. Like,
Yes.
if that little bit of salary is making the sole factor that is making the difference between exempt and non-exempt, I'd be surprised. I think you probably have a lot of people at that level that may be misclassified. Someone, I hear this phrase every once in a while, salaried exempt. Still not
Love
quite sure what that means. But I know some HR professionals who use it, and if you're paid a certain salary, then you must be exempt from the overtime rules. But it's not to say that someone can't make in the 40s or 50s and be exempt. It could happen, but usually it's not the money that is
Not in
driving
California, can't.
factor. Well, right, exactly. Because right, some states, California, New York, others, like it's not going to matter what's going on with the salary level test at the federal level. Well, we are at 12:53. We do have time for some questions if people want to ask. Otherwise, I could do a song and dance, or I could just make up questions and toss them out to the audience, or toss them out to our panelists. Actually, I do want to ask one while our chat's getting warmed up, and I'll put this out for anyone. Is there are there certain employment laws, rules, regulations that could be on the fence, but you don't think will end up changing in 2025? I mean, I don't think the Fair Labor Standards Act is going away, but I'm talking more in the gray area. John, you look like you have
I
something.
mean, I don't think Title VII's going away, but
Right.
I have, and I don't think, and we have the Bostock decision, but I think you're going to see an assault on trans rights in the next administration. Ohio is poised to pass a transgender bathroom law for schools and universities, requiring students to use the bathrooms of the sex they were assigned at birth, for example. And I just read that there was a bill that was just put on the floor of the House, that would make it that would require the same on Capitol Hill. Which is interesting since there was just a first transgender person was just elected to the House. I think we're going to see a massive assault on trans rights. That is, if I can editorialize, I mean appalling. Um, but they're going to have the votes. But they're going to have the votes to pass those kind of laws if they want to pass them.
Right. And we'll see a much bigger, I think, renewed interest, like we kind of saw with it during the pandemic, on religion as a basis for that. I mean, look
I
what Florida's done, you
I
know.
think I think overall we're going to see some shifts in terms of enforcement efforts. I think some resources are going to be redirected away from the agencies on certain, areas of enforcement that in the past have been a priority. So I think that's going to kind of rechannel, not necessarily taking away the right on the books, but what do we choose to actually enforce or litigate on behalf of the EEOC or OSHA or the other agencies? So that was.
And
It'll
let
be, yeah. And I think to that point, Desi, I think one of the interesting dynamics is going to be I-9 enforcements and investigations because you have two competing interests that are supposedly in being favored by the Trump administration, like a sort of pro-employer, but also a ban on undocumented workers in the workplace. And there are certain industries that we know in landscaping, in restaurants as well, that have historically relied on some of these undocumented workers to fill positions that in many cases otherwise would go unfilled. And so are they going to be doing more audits of I-9s? And if so, like what industries are going to be targeted there? And I find that fascinating. The one other thing I'll just say briefly is we've seen a loosening of some child labor laws at state levels, and I'll be interested to see where that goes in the next 4 years because we've definitely seen that trend happen of allowing more kids in the workplace, and does that get loosened to allow more kids to work in workplaces that might otherwise fill those positions?
I definitely think we're going to see an increase in I-9 audits and just in general rating a lot of workplaces for, enforcement by ICE. I think that the retail and hospitality industry is probably going to be targeted, and that is definitely one of the priorities of the administration. So I think we're going to see a lot of resources put behind that immigration push.
All right, folks, we're getting to the top of the hour. I want to thank the panelists. I want to thank the audience for attending. I want to give each of the panelists a few seconds to shout out whoever they want to shout out or tell us a little something about what's going on in their lives, their practice, their families, whatever. I'm going to go the reverse way this time. We went clockwise. I'm going to go counterclockwise. John, tell everyone what you got going on in the world.
I would say have I've been off X for the past year because Elon, and I got tired of seeing swastikas every time I opened up the app. But you can find me now on Threads at the John Hyman and on Blue Sky at John Hyman for all your 300 and 500 character bursts of employment law and other goodies.
And folks, if you scroll up or down in the chat, you can see I've posted links where you can connect with us on LinkedIn. I'll do it again as Desi tells us what she's got going on.
I just want to thank everyone for joining us. This is incredible. I don't know how many folks are online, but what an incredible opportunity for us to be in community during a time of change that makes everyone a little uncertain. And so it's a wonderful opportunity. I'm still enjoying my nature walks in the morning. If you follow me on LinkedIn, you'll see my sunrise photos and kind of, trying to focus on that. And I was thinking at, trying to figure out an analogy between the state and federal level. I was thinking if I'm in the car with my two girls and they're blasting off their music and I want to drown it out, Or am I cool with it? Am I cool with the federal rules? Or do I want to drown it out? Because so the competing interests are going to be interesting to monitor.
All right. Amy.
I like the analogy now that I am not driving children around. I like it. I want to thank my dog for not barking during this session. I was a little bit worried about that. You can find me on LinkedIn, really. I was very active on Twitter, now X, and I really have just stopped posting or even checking it. The one thing we really didn't cover, and I just want to say, is I think we are going to continue to see increased anti-Semitism in the workplace. And I think that's going to continue to be an issue. It is violation of Title VII based on race and religion, depending on the type of conduct or comments that are given. And I just don't see that going away anytime soon, given what's going on with the Middle East and what's going on in workplaces and what is going on in our communities. I want to thank you, Eric, for always inviting me to these. I very much enjoy them. But please do connect with me on LinkedIn or via email. I'd love to hear from you. Thank you.
Dan, close us out. What's going on?
Yeah, so Eric, thanks very much for the invitation to my fellow panelists. Love following you, and you can find me on LinkedIn. But if you want something completely different, because we can talk about law all we want, you can follow me on Instagram at The Lawful Explorer, where I don't post anything about the law. I'll post restaurant pictures. I'm in with all these influencer foodies from Connecticut. It's fun, and I would encourage everyone, have something outside the law, outside of HR. We all need it. We need a little more light in this world, and you know, find me there. Stay off of X and the social medias.
Awesome. Well, thank you, Dan. I learned something new about you. I'm going to follow you on Instagram. That's great. Well, folks,
I'm
thanks.
A Yelp elite. So there you go.
La-ti-da. I
I
didn't
know.
know. Wow. Well, folks, thank you again for attending. And yes, I see the comments, the questions. Yes, this was recorded. I did remember to hit the record button. It will be posted to YouTube. And if I'm feeling real good, I'll even put some chapter markers in there so you can skip ahead and back and all that kind of stuff. But thanks so much for coming out. And apparently we're going to have to put together an immigration law panel. I posted that in the chat, so perhaps that'll be coming up sometime soon. Look out for that. If you have other ideas about other panels and Zooms you'd like to see, just reach out to me on email. And otherwise, enjoy the rest of your week. Thanks a lot.
Cheers, everyone.